Beyond the headlines, the UK civil justice system is a crucible where rights are forged and wrongs are challenged. Each stage is a strategic battleground, fraught with peril and potential for profound impact on individuals, corporations, and society itself. Understanding these critical phases is essential for legal professionals, students, and an informed public. Disclosure mandates that each party reveal all relevant documents, regardless of whether they support or harm their own case. This crucial stage ensures transparency, preventing trial by ambush and laying bare the factual foundation of the dispute. It is a cornerstone of fair adjudication. In the monumental Bates v. Post Office scandal, the disclosure stage proved pivotal. The Post Office was compelled to release internal documents concerning its Horizon IT system, exposing critical flaws and undermining its credibility. This dramatic revelation fundamentally shifted the case, vindicating the wronged sub-postmasters. This stage is a goldmine for dramatic revelations, where a smoking gun document or hidden emails can upend an entire case. It creates high tension, offering classic plot twists for legal narratives and highlighting the power of evidence. Case management, often through a case management conference, sees the judge actively preparing the case for trial. The court sets strict deadlines, issues directions, and actively encourages settlement or alternative dispute resolution. This ensures efficiency and proportionality in complex proceedings. While less overtly dramatic, case management involves crucial strategic decisions that can alter a case's trajectory. Rulings on late evidence or expert testimony can significantly impact a party's prospects, making this a critical juncture for legal strategy. This stage offers a glimpse into the intricate legal strategy and judicial oversight shaping a case. It can showcase last-minute tactical shifts or stern judicial warnings, raising the stakes for all parties involved. Interim applications are urgent requests made to the court before the main trial, seeking temporary orders. These can include interim injunctions to compel or prohibit actions, freezing orders to preserve assets, or specific disclosure requests. They demand immediate judicial attention. High-profile cases frequently feature dramatic interim injunctions, such as those preventing sensitive publications. The historic Spycatcher litigation saw newspapers battling government gag orders, demonstrating the immediate and profound effects of these pre-trial interventions. Interim applications introduce urgent, high-stakes hearings. Will the court grant an injunction that could make or break a business, protect a vital secret, or halt a controversial development? The outcome can be instantly life-altering. A party can apply for summary judgment if they believe the opposing side has no real prospect of success. If granted, the court decides the case, or a significant part of it, without the need for a full, costly trial. This offers a swift, decisive resolution. Summary judgment can abruptly conclude months of preparation, often with devastating consequences. In commercial disputes, a well-timed application can save a business from protracted litigation or, conversely, lead to its sudden downfall. This is a moment for sudden reversals, where one side, expecting a full trial, finds their case decided against them in a swift, dramatic hearing. It underscores the court's power to streamline justice. A strikeout application asks the court to remove all or part of the other party's case. This typically occurs if the claim lacks reasonable grounds, constitutes an abuse of process, or is otherwise fundamentally defective. It's a procedural safeguard against vexatious litigation. Strikeouts can eliminate weak or vexatious claims early, sometimes with significant consequences for access to justice or public interest cases. They highlight the court's role in maintaining the integrity of the legal process. A strikeout can be a devastating blow, especially if a technicality defeats a claim with perceived moral merit. This creates compelling ethical dilemmas and emotional drama, questioning the balance between procedure and justice. The trial is the main event. Both sides present evidence, call and cross-examine witnesses, and make their legal arguments before a judge. It is the formal arena where facts are tested and legal principles applied. Donahue v. Stevenson, 1932, famously established the modern concept of duty of care after a snail in ginger beer led to a groundbreaking trial. R.V. Dudley and Stevens, 1884, involved the sensational and morally complex trial of shipwrecked sailors for cannibalism. Courtroom confrontations, surprise witnesses, and emotional testimony are staples of legal drama. The trial is often the climax, with high tension and dramatic reveals, where the fate of parties hangs in the balance. After the trial concludes, the judge delivers a formal judgment. This explains the court's decision, outlines the reasoning behind it, and specifies the orders granted, such as who wins and what remedies are awarded. R.V. Brown, 1993, saw the House of Lords judgment criminalizing consensual sadomasochistic acts, a dramatic and controversial moment that sparked widespread debate on personal liberty. Judgments can shape societal norms. The judgment can be a moment of triumph or despair, often delivering surprise outcomes, revealing moral ambiguities, or offering profound social commentary. It is the definitive statement of legal truth. If the claimant succeeds, the court determines the appropriate remedy. This can include damages, monetary compensation, an injunction, an order to do or not do something, or declaratory relief, a formal statement of rights. Remedies can have far-reaching effects, as seen in Intick v. Carrington, 1765, where the court's declaration dramatically limited government power and protected individual rights. They are the practical outcome of justice. The remedy can be as dramatic as the verdict itself. Will the court grant an injunction that fundamentally alters lives, or award damages that bankrupt a party? The impact is immediate and tangible. The losing party may appeal to a higher court, arguing that the trial judge made a legal or procedural error. Appeals focus strictly on points of law, not on re-evaluating facts. This provides a crucial layer of judicial review. The Observer and Guardian v. UK Spycatcher case saw newspapers appeal to the European Court of Human Rights, dramatically reversing UK court outcomes and setting precedents for press freedom. R. Miller v. Secretary of State for exiting the European Union, 2017, involved the Supreme Court's dramatic assertion of constitutional principle regarding Brexit. Appeals offer opportunities for last-minute reversals, new legal arguments, and high-stakes decisions that can have national or even international impact. They underscore the enduring pursuit of justice. These stages are not merely procedural steps, they are the very fabric of justice, each imbued with strategic depth, dramatic potential, and profound implications. For law students, legal professionals, and the public, understanding this journey is paramount. Delve deeper into these critical stages. Explore landmark cases, engage in legal debates, and consider how these processes shape our society. Share your insights and questions in the comments below, and subscribe for more in-depth legal analysis.